Hi, welcome to Victim to Victory, the definitive authority in personal injury. I'm Lawrence LeBrocq, managing partner of Garces, Grabler LeBrocq, and I have the pleasure of having Rajat Bhardwaj with us today, who is a lead attorney with Garces, Grabler LeBrocq. Welcome to the show.
Thank you for inviting Lawrence.
Pleasure to have you. Let's talk a little bit about your background. Graduated law school, and you went into a clerkship with Judge Goodsuddy. Talk a little bit about why did you take the clerkship and what benefits there are in having a clerkship.
Yeah, so early on in my career, I knew that I wanted to do trial practice. And one of the best ways to become a trial attorney is to know what's going on behind the curtain. How is a judge making a decision? What goes through the process of decision making? And during that time, my judges, clerks, me being one of them, we would write all the decisions of the court. So we would understand what the rules of the court are, what's the case law that's used most in civil practice, whether it's in summary judgment or a motion to dismiss. And it gave me insight as to how judges think, what is persuasive to them, what they like, what they don't like. So it was very important to me to work behind the scenes, work behind the curtain, so have a better idea how to be the most effective litigator possible when I come onto the other side.
And now you're on the other side and you've been there for a decade. So let's talk a little about the practice of law and take us through the steps when you first have a client come into your office. Take us through the process.
Sure. Um, Time and time and again, you've said it. You've said it in your book so many times. Our focus as trial attorneys is to prepare every single case for trial. As soon as a client walks in the door, that is what we're thinking. If we have to prosecute this case to trial, what do we have to do to prepare the case? So, whether that's immediately taking history of the client, understanding what their complaints are, making sure that you're getting the appropriate treatment, but most importantly, as you go over in your book, educate them. Let them know what will make for an effective case, especially if they have to go to trial. So, in our firm, we're always looking at cases through the lens of an anticipated trial. So, from the inception, we make sure that a client's getting appropriate treatment, that if they are pursuing a specialty, whether it's pain management or perhaps eventually a surgery, that they're going to the right doctor that would be prepared to be an advocate for them if the client's case goes to trial. So trial is always on our mind. It is in our blood in our firm. We are committed to excellence and making sure that from the day that the client walks in the door, we provide them with the most effective litigation, which is done through preparing every single case for trial.
Now, does every firm do that?
No. We've all been in different firms. We've had different experiences. We have a very diverse pool of attorneys that work for us. We had attorneys from the defense. I myself had a stint in intellectual property before we came in. Not every firm's goal is to maximize the client's case. We are a trial firm that has a focus of making sure that if one day the client's case goes to trial, we are ready. We are on the client's team. We are not looking out for what is going to make the firm the most money or the quickest way that the firm can make money. What we want to do is make sure that ultimately, if we're going to recommend a settlement or if we're going to try the case, the client is in the best position possible.
Now, what is the importance of managing the medical care? And that doesn't mean telling people to go to specific doctors, but what is the importance of managing medical care?
Absolutely. When we go to trial on a case, the job of the attorney, in addition to being an advocate, is making sure the story of the client is heard. Much of that story comes from the doctors that they see, the history of their treatment, the injuries, and how they've been impacted and affected through the through the recovery process. It is important that they are with a doctor who is not afraid to be on the stand, be an advocate for the client, and not every doctor is comfortable doing that. If a doctor is not comfortable doing that, that can eventually become an obstacle for the client's case. And as their well wishers, as their guardians, as their champions, we want to make sure that their case is presented in the best way possible. And one of the most important factors in that is having a doctor on the stand who knows how to testify, who's comfortable in court, and doesn't shy away from being an advocate for our clients.
Well, there's a lot of doctors out there that are fantastic board certified surgeons that will come to court and testify.
Yes.
So that makes our job a little bit easier. But I couldn't agree with you more. If somebody is not willing to come to court and testify, it's really a disadvantage to the client because then you have to get what's called an independent medical exam for some and send them to a doctor for just a one-time visit as opposed to the treating physician.
Yeah, it's honestly a disservice to the client because uh, doctors are aware that the client has suffered, whether it's a motor vehicle accident or a premise fall or a variety of negligence-based claims. So if that person who's treating you for those injuries, who's taking your history, does not provide that testimony in court, it can really hinder the client's case. So the difference in having an IME, the one-time examination, mostly, which is done by defense attorneys, is that they don't have that experience in treating it, right? And chiropractors, as you know, as you mentioned in your book, are one of the most important doctors for our clients. And one of the reasons is that they see them for such a long period of time.
Right.
Months, could be a year. So they're really seeing the progression of the treatment for the client and seeing how they recover over time and are able to comment on that. So it's not only coming from the attorney, it's not only coming from the client or their family members, it's coming from medical professionals who know what they're doing, who are board certified, who may be certified to read MRI films, and commenting based on objective evidence.
And it's amazing. A lot of people don't know that chiropractors only work on the spine. They're really experts in the spine, and the good ones will quarterback the treatment. And if somebody isn't getting better from chiropractic treatment, isn't improving, they'll get them out to the appropriate pain management doctor or orthopedic surgeon. And those are the guys and women that we like to use at GGL.
Absolutely. We do want a chiropractor that's well connected because of the long term care that they provide. They sometimes can be in the best position to recommend care to a pain management physician, an orthopedic doctor, a neurologist. They are on the front lines when it comes to care of our clients. And you want to use the right chiropractor who's well connected, who knows how the system works, and is able to provide appropriate recommendations when the time is right.
And the other issue is in New Jersey, we have PIP, which is basically medical insurance through your automobile insurance, and that is what has to pay the bills. And then there's some doctors that don't take PIP.
We have a no fault state in New Jersey, and the medical bills, as you mentioned, initially at least, are paid through PIP, through whatever policy our clients have selected. We're always encouraging clients to have large PIP policies, standard policies, which are 250,000 in New Jersey. And that's important because no amount of compensation will ever make you feel the way you did before the collision happened. And that's really what's most important, our clients' health. Sure. So when you're dealing with doctors, whether it's chiropractors, pain management physicians, orthopedic doctors, you want to make sure that their office knows how the PIP process works, that they're able to file claims timely, appropriately, that they're able to appeal, because we know ultimately the job of the insurance carrier is to deny, 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 minimize, minimize, minimize. And you need the right team, even in your care, of, of doctors that know how to work in the system and appropriately make claims and make sure that they're reimbursed and they're following the PIP guidelines.
So tell us a little bit about the cases you handle. You've been practicing law for now over a decade. What types of matters are you handling, and in what area of the state of New Jersey are you handling these cases?
Certainly, um, at Garces, I serve as the Bergen County and Passaic attorney. I handle all North Jersey claims, could be Passaic, Bergen, Hudson, Essex. Um, but we have such a variety of cases in our firm. Um, Motor vehicle accidents, slip and falls, that's definitely the larger volume. But we have very complex cases when it comes to liability, right? We can have a light malfunction. We could have a third party case and that turns into a product liability suit, medical malpractice. So we certainly, the larger volumes are autos and slip and falls, but the more complex cases, which we have many of, can be wrongful death, they can be medical malpractice, it can be product liability, um, various negligence based claims. And to add to that, we're a very large workman's comp firm, and from that stems the third party claims, and they can also be quite complex.
And just for our audience, what is a third party claim?
Certainly. So workman's comp is a claim against the employer for benefits if you are hurt within the scope of your employment. Now, if a third party is negligent, now an example would be, let's say someone falls from the ladder and the ladder's defective. Someone is on the job and driving their vehicle and there's an auto accident. In these scenarios, there's a third party. There's the driver, there is the manufacturer of the ladder. So these claims stem from negligence of these actors. The workman's comp claim is a right of an employee to be compensated when they're injured within the scope of their employment, and that goes to the employer. But the third party claims is for the bad acts of a third party, like I mentioned, a ladder company or a negligent driver. And there are ways to get compensated from those bad actors as well.
And yes, with all those workers' compensation cases that we have in the office, when a third party case stems from an automobile collision, it's a little bit different because then the primary source of getting your medical bills paid are your workers' comp carrier. So it's very important that to know that, and we can handle it all in house because it's what we do.
Absolutely. Um, when there are various ways that your bills, medical bills, can be paid. PIP is one. When you're in an auto accident, you may end up utilizing your health insurance if you're in a fall. If there's no coverage, you might go through the state with something called PLEGA.
Sure.
And if you're injured on the job, you're going to go through workman's comp. Um, there are intricacies for all of these health benefits. When you're going through comp, all of the medical treatment is authorized by the insurance carrier for the employer. When you're going through PIP, you want to make sure that the doctor that you're going to takes PIP insurance. So, but the way that doctors are compensated is separate, and the treatment that you can have in those situations is also different. The path to treatment is different in those situations.
Very different. And I've had many of the comp attorneys in here talking about unauthorized treatment because a lot of times uh, the workers' comp doctors, they're paid for by the defense or the insurance company. They do not want to authorize certain care. So we have to take them outside of the workers' comp and get them out for what's called unauthorized treatment.
Absolutely. And that's why you want an experienced advocate when you are in a personal injury action. Because, um, these are people. And sometimes we forget that. Our clients, it's not just that someone was in an auto accident or a fall or got hurt on the job. I mean, their lives are wrecked,
Sure.
right? Their families, especially if they're the primary earners. How many times have we seen that, right? the entire family is depending on this person who can no longer work properly. So it's very important that they get better, right? So if you're going through workman's comp and you're getting denied, you need that champion on your team. You need that personal injury attorney who's going to get you the unauthorized treatment. Make sure that treatment is paid for by the bad actors, um, and get you to the best position possible in terms of your health as soon as possible.
Now let's talk a little bit about you and your background. I know you studied martial arts, Muay Thai and Brazilian Jiu-Jitsu. How does the discipline that you develop through the martial arts, how does that help you as a litigation attorney? Because it's a very demanding job that you have.
It's a very demanding job. Um, they are You have expectations of yourself, the clients have expectations of you, and we are in a litigious system. So you may have aggressive defense attorneys. You may have to be aggressive yourself to make sure your client's needs are being met. But when it comes to martial arts, one of the uh, most important mantras of martial arts is these are defensive arts, right? Um, you don't learn martial arts to pick on somebody, right? You learn them to defend yourself, right? And defend others, perhaps, right? And what you learn in martial arts is in order to avoid confrontation, you always have to be prepared for confrontation, right? It goes to the book Art of War, right? How do you avoid war? A war? You make sure you're prepared for war, right? And that's what we do at this firm. We are prepared for war from the day that the client enters our offices, and we are preparing for trial every single time we see them on every single item that we work on, whether making sure that the medicals are there, making sure that we have the right experts, the reports, animations if we're going to trial. We are ready.
And one of our KPIs is to try at least 2 cases a year.
It's an expectation that we have. And um, if we could talk a little bit about mentorship and how important that is to you, and the coaching that you've done, it's the same. It's the same uh, themes that we're bringing to this firm. We want to build a skill set for attorneys. When we're hiring attorneys, we're not looking for perfection. We're looking for commitment, right? And no matter what level of litigator you are in our firm, we have programs for you to make sure that you get to the certification standard. And two trials a year is just an example how there's an expectation that you continue to build a skill set, just like learning jujitsu or Muay Thai. You have to work on it every single day. You have to spar. You have to go to competitions to make sure that you're on the top of your game, right? You are competing against yourself to make sure that in a month's time, in a year's time, in 5 years' time in our firm, you are continuing to progress. And we have systems in place for that. We have mentorship programs in place for that.
And the amazing part at our firm is most people are very successful and follow the mentorship, but the ones that don't seem to just leave the firm.
They fizzle away because we want people that are aligned. Um, and when we say that we're a trial firm, it's not, this is not just a catchphrase. We are invested in this, and we are invested in our attorneys. The lawyer that I am now than what I was when I started in the firm, it's very different. I've done numerous trials through our programs, through the opportunities that our firm has provided, and it's made me a substantially better trial attorney and litigator because ultimately it's practice, practice, practice.
It's kind of like I always say to people is it's almost like football practice. You don't just want to practice all the time. You want to participate in that game. That's what it's all about. And that's
Yeah.
the way I look at a trial is your opportunity to show what you've learned and improve your art.
Yes, and Lawrence is always encouraging people to try cases, and you very openly say that, look, I don't care about what the result is going to be. My focus is to do what's best for the client, and that many times is to go in a trial and do what's best for your development as an attorney. And um, it's one thing that you know things theoretically, right? Maybe you see some videos, maybe you've done some motion practice, but until you're in the ring, right? Until you get those jitters, until we were talking about this other day, you know where to stand when you're in a courtroom, right? Until you go through those experiences, progress is not going to happen. You have to do it. So, as you were saying that, look, the attorneys that are not with us are not interested in this type of work. They're not aligned with what is important to us as law firm.
It's so true. And we're always looking for to bring people on that want to be a real trial lawyer. Because if that's what they want to do, ours is the firm to do it. And we've had so many attorneys preach on that that have come from other firms.
Absolutely. It's important to us because, uh, as I mentioned in the beginning, we are looking through the lens of trial every time the client comes. And that is the only way, by the way, to look at a case,
Sure.
right? When you're preparing the case, you're preparing the case for trial, period, right? Maybe five, less than 10% cases go to trial, right? But the reason that's happening is because we're prepared,
Sure.
right? The reason we are getting the best settlements, that we are maximizing value in our cases, is because we're ready. Just like in martial arts, we're prepared for war, but we don't want to go to war.
Sure. If we can settle it for the reasonable, fair value, we'll take that settlement. But if the defense does not want to offer that value, we're ready.
We're ready. We're ready.
And that's what we do. Tell us a little bit about some of your experiences at trial, some good results you've had, and how you've progressed over the years.
Yeah, a lot of my stories are, I hate to say, defense attorney and judges saying your demand is too high.
I wonder why.
Your demand is too high. There's no way you're gonna get this. There's no way a Bergen jury is going to rule on your behalf on a verbal case and put X amount of dollars, especially given that your client has prior uh, collisions, prior motor vehicle accidents. And lo and behold, when we present the case appropriately, when we have the right experts on the stand, when we advocate for our clients, when we prepare our clients for testimony and they know what to expect and what to say, the jury sees through the BS that's being presented by the other side because their job is to minimize, to use words like degeneration, age related changes. And we all know that prior to the collision, the fall, whatever the negligence may be, they were a different person. They didn't have these complaints when they can't sleep at night, when they wake up with a throbbing headache because their neck is in pain. When we present it the right way, the jury sees through it and they rule on our behalf. And we see it the majority of the times. So, um, over time, as I've tried cases, I've only started to believe more and more in our system because the values that we set are frequently the values that the jury decides of a case. Um, and the values what we set is frequently, if we settle the case, that's what we settle for.
Yeah, the guy that sets those values has been doing it a long time, a lot of counties.
And he's been an arbitrator in a lot of counties. I mean, he's been all across the state. So we're not just making up these numbers. They're based on facts, they're based on research. Not only your research, but you talk to other lawyers. We uh, we have people of varied experiences in our firm, and it's and I have to say, you're open to other people's perspectives. You're open to hearing why a case should be worth less or why a case should be worth more. And that's when we have our meetings, those are some of the things that we discuss.
And it's very important at this firm to maximize the value of every claim. I had a lot of defense lawyers come join our firm and say, "Oh, I'm never going to get that. I'm never going to get that amount." And then they get the amount. Well, when John Gagnon came over to the firm, he's like, "Oh, this is great. Your numbers are so high. I'm going to get to try cases all the time." And he finds out they come to our numbers because they're really not that high. The problem is most firms and a lot of judges, unfortunately, have allowed over the years the insurance companies to set the values of cases, not the juror and not the plaintiff side. And that's what we're trying to combat.
A good example of this is I had a case in Bergen County, and our client had two prior accidents. He was a ER tech, and everybody was saying that you're gonna get no cause. It's a verbal threshold case. You're gonna get maybe $5,000 to $10,000 for the case. That was the initial offer being made. Judges, same thing. You're in Bergen County. You're gonna get no cause. Not only did we hit our offer of judgment, we got almost 10 times what the expectations of the judges and the attorneys was in that case. So even when we sent our order our offer of judgment, and to explain that's a number that we will decide on, and essentially um, make an offer to our adversary that, look, we can settle for this amount, or we'll go to trial, and if it's above this amount, you're gonna owe us attorney fees, you're gonna owe us a cost, etc. Um, so when we're choosing these offers of judgment based on the numbers that we discuss, based on the experience, most of the time it's playing out, uh, and that those numbers are hitting.
When a client comes to you in that initial meeting, what are some of the most important things you tell them they must do and what you can't do this?
The must do's have to be: go to your appointments, don't miss them, because the carrier is always looking for ways to minimize. And one of the most recurring themes that we hear is, well, there's a gap in treatment. You didn't go for 6 days. You didn't go for a week after the accident happened. So one of the most important things that we explain to our clients is that you must be consistent in your treatment. Most importantly, so you get better, but also for the purpose of litigating your case, so we can tell your story to a juror. Um, when it comes to paying for their medical treatment, we explain to our clients, these are the policies that you've chosen. These are uh, these are the limits that you have, and although we are checking on our end, if you get the hint that you're about to cross these limits, let us know, so we can help manage the costs. Um, but in terms of the don'ts, social media is big. It is. Uh, it can get a lot of clients into trouble unintentionally. Unknowingly, they will post things doing that may make them seem like they're particularly active, right? Uh, it gives the defense an excuse, uh, or um, a sticking point if they see you on vacation in the Bahamas, even if you're relaxing on the beach. Well, were you doing any activities? Were you surfing? What about the plane ride there? If you're complaining, then how did you manage the 4 hours flight to the Grand Cayman Islands? How did that happen? So, um, it's about educating your client. It's about letting them know, hey, these things will be used against you. Our job is just to educate you. And most of the time, clients will listen, and they will manage your life based on the recommendations that we're making.
If you give any advice to people, what would that be that are involved in a trauma?
Get an attorney as soon as possible. If you're in a motor vehicle accident, if you're in a fall, you want an attorney to give you guidance as to how you're going to go through this journey. You want a champion by your side, whether it's the initial stages when you're getting treatment, whether it comes to prosecuting your case in court, you want someone by your side as soon as possible. Get an attorney quickly and get the right attorney who's ready to fight for you to the very end.
I've actually had clients call me from ambulances. That might be a little too early. I would suggest
Yes.
get out of the emergency
Get her out of
room
the emergency room
and then give a call.
because you're going to start getting those bills and you're not going to know what to do with them. You want the right guidance from the inception. And look, it doesn't cost anything to see an attorney, especially in our industry in personal injury. Our goals are aligned with our clients. It doesn't cost anything, and it can save you a lot of headaches in the future, and it can also assure that you maximize the value of your case.
Yeah, just like all those billboards of ours say, no fee unless we win, so they don't have to worry about that.
No.
So other than that, why GGL and why should they come see you?
We have a core belief system that we treat every client like family, like they were an extension of us. We are focused on excellence. We are focused on being accountable, being honorable. We are focused on making sure that your case is ready for trial. When you come to us, you have absolutely no fear because you are getting the best representation possible. I, for one, am someone who's constantly looking through the lens of trial for our client's case. I'm making sure that we're helping them in every aspect of their personal injury claim, whether that's their treatment, whether it's the actual prosecution, whether it's other things that come up. Because ultimately, it's not just the medicals. There are other aspects of your case, vocational. If you can't work, there are ways to make that part of your case. If you're going to need future treatment, but you're not going to be able to complete it within the time frame of a lawsuit, that's something that needs to be made part of your case. All of these items, a regular person on the street may not know. It is not taught in school. It's not taught in college. And that is why, from the beginning, you need an expert with you.
Thank you, Rajat. Rajat Bhardwaj, lead litigation attorney with Garces, Grabler, and LeBrocq. It's great to have you on the team, and thank you
Thank
for
you for
coming.
having me, Lawrence. I appreciate it.